1 minute. All right, guys, and if you have any questions, please feel free to use the Q&A chat. Thank you.
Thanks, Jennifer. So we all should be aware of what happened at Surfside, the incredible loss of life. There was a slew of legal and property management related issues that were really born from this terrible event. The unexpected building collapse is likely to cause, in my opinion, and many other community association practitioners, a monumental shift in the decision-making process and procedures, particularly for high rises in South Florida, if not the entire state. And I know some of you don't manage high rises, but these concepts are still important to understand. Here in Palm Beach County, the Board of County Commissioners has ordered a task force be formed to study the issue for the purposes of instituting its own recertification process for high-rise condominium buildings. That recertification process, which currently only exists in Broward and Miami-Dade, mandates that condominiums be certified that every 40 years that all structures are sound and being fit for occupancy by its residents. The task force is gathering building permits from the last 50 years on every condo building, which is 3 stories or higher. So although much of the attention is likely to focus on the high-rise condominiums, especially those on the beaches, this still could have an impact across the board involving all types of condominiums, whether high-rise or low-rise, and potentially homeowners associations, but perhaps less likely. Some other interesting facts. The median age of a beachfront high-rise building of 10 stories or more in Palm Beach County is 40 years. That happens to be the same age as the Surfside condominium that collapsed on June 24th. So a number of high rises here in Palm Beach County are going to be impacted and going to be subject to this likely recertification procedure that's going to be implemented, in my estimation, within the next 6 months or so. Other counties going to be affected as well. Martin, St. Lucie, they're looking into the recertification process, that they'll probably follow suit. Given the gravity of events on June 24th, the recertification process that Palm Beach County is likely to adopt is not going to be 40 years. It's going to be a much tighter time frame. There's been some scuttlebutt among the Board of County Commissioners, certain commissioners that want to have a 5-year recertification process. Perhaps it turns out to be a 10-year, perhaps 15, but it'll be even tighter time frame than what currently exists in Broward and Miami-Dade, and that's likely to be modified as well from 40 years downwards. So what will this mean to you as a property manager? You're obviously going to be tasked with coordinating efforts with the necessary structural engineer to inspect the building structures, to have reports written and have those reports disseminated to the board of directors. You're going to be a conduit for that purpose and to organize those events and coordinate all that needs to go on with the engineer. Your obligations obviously will not end there. You will be to some degree responsible for analyzing the findings of the engineering report for purposes of putting the engineer's recommendations into action. That's a scary concept, from the standpoint of being a property manager. And I fall into that same category as you folks. I'm an attorney. I'm not a structural engineer. In fact, I was pretty good at English, not so great at physics. So that's why I went to law school, and I didn't become a math wizard.
Question for you, Scott.
Sure.
Can you touch on assessment increases outside the declaration? Example, is there an appropriate point when the association can raise assessments above what the declaration allows? And would this increase require membership approval?
Okay, let me get through the Surfside stuff first, but I will circle back to that question later on, probably in section 3, but feel free to remind me, Jen, okay?
Good, thank you.
So I want to stay on the topic of the Surfside and what that means. And so, while like I was saying, I have great respect for engineers and their important work, these reports are not always clearly written. And it's not always super clear what needs to be done in terms of a repair or renovation standpoint. Vague conclusions in a report can lead to a lack of guidance and unclear directives for you to share with the board of directors that you serve. So what does that mean for you again? Follow-up questions, inquiries are going to need to be made, probably by you, to the hired engineer, asking direct questions as to what specific work is recommended and by when. You're going to have to not be shy about trying to pin down these structural engineers, because these reports sometimes are written in a manner in which it suggests certain things but doesn't mandate. So you're going to request and need clarity as to the findings in the report so you could properly guide the board of directors and pass along the information to the board of directors for them to make the ultimate decisions. And it's important, all these communications that you have with the structural engineer and with the board of directors that you serve are in writing, by email. So there's a paper trail. So you avoid this situation of an engineer saying down the road, God forbid something happened to one of the buildings that you were managing. Well, I told such and such property manager that we needed to do this or do that. Well, conversations, he said, she said type scenarios are exactly what you want to avoid. You want to have things in writing so it's clear cut and you can refer to it in the event that you need to later on. Lawsuits have already been filed involving that Surfside disaster, and potential defendants in those lawsuits and actual defendants include not just the association itself, but the property management company, potentially members of the board of directors, as well as potentially the attorney, if the attorney didn't properly advise the board of directors to the extent that the attorney had information. So there's a whole mountain of exposure here in these situations, and it's dangerous stuff. And so you just have to do the very best you can to, for lack of better words, CYA yourself when these reports come in. Make sure they're swiftly provided to the board of directors, and ask for instructions from the board of directors, and ask follow-up questions to the engineer, and disseminate that information to the board.
Scott, can I ask a question real quick?
Sure.
Is there going to be, I did a conference call, I'm on the CERA committee for the FSEPA that we talked to DPR. And one of my concerns is, it's great that they're suggesting that. Is there going to be any accountability for that? What I mean is, right now, like if you're in an association and they do something wrong, unless somebody complains, it doesn't really go anywhere. So like if this report, is somebody going to be overseeing it, that it's done? Like, how are they going to manage that? Do they even know yet of how they're going to manage these reports, who they're going to turn it into to make sure it's even being done?
Well, that's going to fall at the feet of the property manager to a large degree, as well as the board. I mean, I think it's a good way to go is for the board to identify a liaison at the board of directors level to oversee the obtaining of the report and asking questions through the property manager, have a point person for that purpose. And frankly, if you have an engineer that is not providing clear instructions or the report is being delayed because they can't get to it, I mean, it's going to be incumbent on the property manager to find another engineer if necessary. So, the property manager is the point person for virtually everything that that the association has to deal with. A tremendous amount of responsibility and potential liability. So, I really feel for the property managers that I work closely with, that they have to juggle so many things, and this is a biggie, obviously, and it has to be really carefully monitored and dealt with. And if you have a board that's ignoring the findings in the report, further correspondence, again, in the CYA type manner, has to be sent to the property manager, has to be sent by the property manager to the board stating, I provided you with the report. There are certain recommendations in the report. You have not authorized me to hire the contractors to address these items. So that way there's a record again that as you as a property manager have done everything possible to address potential structural issues and dangerous conditions within the community.
Okay.
So these events, you know,
For you,
obviously,
Scott,
I'm going to,
sorry, I have two questions. While the county is reviewing revised legislation for buildings, how will submissions of building permits, regardless of building type, for renovations of existing buildings, will there be an obvious backlog?
sure. Yes, there seems to be a backlog with everything these days. And I think the processing of building permit applications is no exception. It obviously depends if this is unincorporated land, you're dealing with the county versus incorporated territory in a particular municipality. Some are obviously better than others, so I can't say across the board, you know, no matter what, there's going to be delay. And you know, I work and live in the village of Wellington, and they're pretty good around here. They get to things pretty swiftly. But that may not be true in the municipality where your building sits, or if it's unincorporated and it's Palm Beach County. Things in Palm Beach County tend to be a little slower, but you have some, you know, well-intentioned folks working there, and they're doing the best they can. But it's a case-by-case basis. Okay,
So the best business practice rule won't protect BOD in the event of this type of disaster?
well, the business judgment rule, which is something I'm going to touch on later, could and usually will. The business judgment rule, real quickly, states that a member of a board of directors that makes a decision as to any issue pertaining to the association is, generally speaking, insulated from liability. The policy behind that business judgment rule, which is a concept that is well regarded throughout the state of Florida and courts throughout the state of Florida, is that as a volunteer on the board of directors, you make a whole range of decisions on behalf of your community. And we want to encourage folks to volunteer. And as a result of you volunteering and making some decisions, we want to take away from the potential that you as a board member will be sued for a bad decision. That causes damage to the association. So the business judgment rule generally states, no matter how terrible the decision might have been by a member of the board of directors, the board of directors as a collective body, a clearly erroneous decision and clearly negligent decision will not give rise to liability. Now, there are certain exceptions to this rule, like everything, or exceptions to virtually every rule. And the exceptions being if a board member embezzles money, or a board member engages or hires a vendor where that particular board member gets a kickback, or that board member does something intentionally with malice against a particular member of the association. Those scenarios are not covered by the business judgment rule. So generally speaking, the answer is yes. And in virtually all situations, a member of the board of directors could rest easy that they cannot get sued for whatever decision that they make, as long as it is well-intentioned. Does that mean that board member won't get sued? Anyone could sue anything. I could sue Nicole because I think the rim of her glasses should have been purple instead of red, even though I think red is perfectly fine. It was a terrific choice. But if I woke up on the wrong side of the bed and wanted to sue Nicole, I could. Would it be a valid lawsuit? Would it be a lawsuit with any merit? No, it would be frivolous. But you see frivolous lawsuits filed all day long, and you see lawsuits against members of boards of directors happen all the time. Are those lawsuits ultimately dismissed if they are baseless? Yes, but it doesn't prevent a member of the association from ultimately suing a board member in the event that that member thinks the member of the board of directors made a horrific decision. So there's a distinction between, yes, the board member is insulated from liability. That doesn't mean they couldn't get grouped into a lawsuit for some type of thing that happened to the association for which a member is holding the board responsible for. Let me run into these next couple points involving Surfside, and we'll go into a whole bunch more questions. So as a result of Surfside, you're going to have intense scrutiny on the financial health of condominium associations that you're managing, particularly as it relates to the amount of money held in reserve accounts. Reserve accounts are kind of the two words of the year at this point. It's been reported that, and here's another interesting fact, approximately 30%, only 30% of condominium associations in South Florida have fully funded reserve accounts. We all know why, because the intense pressure to keep condominium association assessments lower by not having to budget for fully funded reserves has resulted in 70% of our condo associations not having a proper amount of reserves on account. So the lack of these adequate reserves when needed are going to, when they're artificially low like that, is going to put pressure on you as a property manager. So you really always should be defaulting to the position of advising the board that they should fully fund reserves. Because when that rainy day project comes and this insufficient reserves being held with that condominium association, is going to be a series of questions being asked. Why don't we have adequate reserves? And who are they going to blame? Typically, unfortunately, unfairly, you guys as property managers. So err on the side of recommending to the board to fully fund reserves. Now, you should also suggest on top of that, that your boards complete a reserve study report every 3 to 5 years. A reserve study report, again, as a reminder, identifies all aspects of the association's property that involve replacement costs in excess of $10,000. And that report will reference the remaining lifespan of those items, the projected cost of repair, replacement, in conjunction with what the association needs to fully fund the reserve account to deal with these big ticket items. Now, it's not statutory mandated you get these reserve study reports. Used to be, we used to have that in the statute. But again, our esteemed legislatures in Tallahassee decided to take that away as a burden on the associations because there was pressure politically to take that out in order to eliminate a certain mandatory cost the association would have to bear. That doesn't mean you shouldn't recommend it. And just because it's not statutorily mandated doesn't mean it's not a good idea. And particularly with all that's gone on with Surfside, you guys should be recommending the commissioning of a reserve study report. What you're also going to see, and I'm putting in my prognostication Swami hat, Nostradamus hat on right now, I think come July 1st, 2022, because of the gravity of the events with Surfside, is likely going to be a statutory change in terms of the collection of reserves on the condominium association side. That the legislature, they typically react heavily in these types of situations. And what is being bantied about and what is being proposed is that condominium associations start collecting fully funded reserve amounts in each budget each and every year. That's going to have a big impact, obviously, on your budgets, and it's going to have an impact, obviously, on the assessments that will be chargeable to your members. So I would prepare your boards for that possibility. It's not the law yet, and maybe I'm wrong, and maybe they defer this, or maybe they do a half measure come July 2022. But my guess, again, is that there's going to be legislative statutory changes requiring that reserves be collected in full on a go-forward basis. So that's really all I have to say in terms of Surfside. So that's my part one. Now I'm going to kind of turn it over to Nicole real quickly and let her introduce herself again as it relates to nuances in terms of reserve accounts, because there's a whole series of accounting related procedures and idiosyncrasies that are quite intricate, and Nicole has all the great details about them. It's all you, Nicole.
Thank
Sorry
you.
about that. Sorry, real quick, Nicole, before we
Sure.
move over to you, we have another question about Surfside. What are the ramifications when the engineer and even the board recommend repairs that are not affordable, reported issue at Surfside by residents?
If the repairs are not affordable, is that, I missed that.
Yeah, I'll read it again. What are the ramifications when the engineer and even the board recommend repairs that are not affordable by residents?
Okay, well, if there are an insufficient amount of monies in reserve on the association side to deal with recommended repairs, the board really should be doing the following. they have to proceed with these recommended repairs. Otherwise, they're ignoring the findings of the expert. So they have to raise money to do so. How do you raise money? There's basically two ways. And our friend Derek Lee would fit that particular option one, which is obtain a bank loan. Derek's institution specializes in this, where an association provides, it obtains a loan from an institution for these types of special projects. And that's perhaps the best way to attack it from a financial perspective, so you don't have too heavy of a financial hit on the membership, which would come as a result of option two, which is to impose the very unpopular special assessment. And that's what happens when you don't fully fund reserve accounts. It's kind of like using a credit card, where you're not paying your bills along the way, then eventually it's going to come due, because you're going to have to replace your roof, or you're going to have to pave the parking area, or you're going to have to deal with some other big ticket item. And if you have not been collecting sufficient funds to be placed in the reserve account over that number of years, you have to get the money somehow. And again, it's either obtain a bank loan, and sometimes you can, sometimes you can't, depending upon the credit rating of your association and the collection of assessments and other related issues the underwriting process would reveal. And if that doesn't work out, or maybe it's a combination of the two, you impose a special assessment against the membership, come up with the money to fund that project.
Yeah.
Another question here, sorry. Are homeowner associations included with condo law when it comes to funding reserves?
The short answer is definitely no. And I'm going to touch that later. So that's a kind of bigger topic, and I don't want to steal Nicole's thunder. Let her talk about reserve accounts that almost exclusively involve just condominium associations, but there are some aspects of homeowner association reserve related issues that I promise to get to later.
Okay.
Thank you so much, Nicole. Take it away. Thank you.
Thank you. Thanks, everybody. I'm Nicole Johnson, Pendergrass with Hafer Company CPAs. We're a full service CPA firm that really concentrates in the area of HOAs and condos. I actually did a class last week, about a 3-hour class just on reserves. As Scott said, it is a hot topic right now. Everybody is asking about it. Everybody's asking, where do we go from here? How do we make it happen if we're not funding reserves? And I do second Scott's comment on funding reserves, how important it is. So I'm going to talk about from the accounting side, reserves, how you can set them up, how they should be set up in condos and HOAs. And then I'll talk a little bit about what you should be doing as an association. So reserves under 718, condominium, they are statutory reserves. All condominiums have statutory. They have painting, paving, roofing, and anything over $10,000. The board always has the ability to put out a budget with fully funding reserves and never going to the membership to ask them to waive the reserves or partially fund those reserves. The issue becomes when they've never funded reserves and a board comes on and says, well, we want to put out fully funding, and the cost is just so astronomical that their maintenance fees will go up. So if they can't fully fund those reserves based on an accurate number, what I mean by that is in your budget, you are required to put out a budget with a reserve schedule in the condominiums under 718. So you must present to the owners all of your reserve schedule, the estimated replacement cost, the estimated lives that are remaining, and then the fully funding amount based on that. If you're in the component method, which is the straight line, that means that each line item, you fund a certain amount in that line item for that reserve line item, that money can only be used for that line item. That schedule is required with the budget. And the main reason for that is if you're putting a budget out and saying, we're going to give the owners an option to waive the reserves or partially fund those reserves, they have to know what they're voting on. They can't just vote on it because, wow, the maintenance fees are lower. They need to have knowledge and transparency of what they're truly voting on. So it is required under 718. There's also another method of funding the reserves, and it's called a pooling method. And that was established years ago from the state, stating that we understand the component method is very restrictive in the sense that if you have money in one component and you need it for another, it requires a membership vote to do that under 718. So they established the pooling method. So the ability is that all that money can be used in one pot for any reserve line item. However, a lot of the misperception out there from a lot of board members is that you still don't need the schedule. And I actually, when I meet with DPPR a lot, they said that's the number one complaint, is that the polling schedule is not correct. And I'll give you an example. And anybody that's on here today's call, I do have sample reserve polling schedules that you're more than happy to have a copy of. All you have to do is plug in the number and it does the calculation for you. I'm more than happy to share that with anybody. What happens, what the deficiency is in these schedules is when they're doing the cash flow method, which is the polling method. Let's use painting as an example. Paintings due every 7 years. So they put the schedule out over a 30-year period and they put the painting expense in year 7, but then you don't see it again. Well, it has to be in year 7, year 14, year 21, because every 7 years that expense comes due. So a lot of times that's the problem. The other thing that state doesn't allow is for inflation. And you'll see a lot of people that put in that reserve schedule, the pooling, where every year they're increasing the actual funding 3%. That's not allowed. What you're supposed to do is every year you're supposed to redo that schedule. So next year, when those estimated replacement costs change, you're going to increase funding, but it's not based on inflation. It's based on the changes in those costs. So you want to make sure that the schedule is being done correctly. On the HOA side, I always use this as my example, but it's really the wild, wild west. HOAs have really no structure in their reserve side. So I almost call them like it's really a non-statutory voluntary reserves. They're still set up for reserves in that community because some of them have large amounts of reserves. They have tennis courts, they have a clubhouse. But if those reserves are needed for its unintended purpose, they can be used. It's not restricted like 718. So you want to make sure as a manager, whatever you fall under 718 or 720, that you understand that in those statutes. Now, I've had a minimal amount of HOAs, but some of them have gone out to the community, got the membership vote, and made them statutory reserves on the HOA side. If that happens, then it's like condominium, that they are restricted for those intended purposes. So that's really on the accounting side. One thing I want to say lastly, before I give it back to Scott, is that think about it this way. I always try to say my communities that say, well, we don't want to fund reserves, we're not going to live here. You're actually paying for your portion of it over that 10-year period. So if you're not putting in, and when you go to sell your units, that person that buys in now is paying your 10 years that you didn't put into those reserves. And also the other side to that is think the value of $1. Today, you're not putting away for it. You're not raising the dues. The individual in the building that's on Social Security, 3 years from now, that dollar is really $5 to them. They're not getting an increase, but now 5 years from now, when that special assessment comes, they can't afford it because they haven't put away for it. They're now in a situation where they can't afford it. If you put away every year for it, then it's less likely to hurt them when that project comes due. So I always try to say that to my managers to try to educate the owners on why reserves are so important. Back to you, Scott.
Thanks, Nicole.
You're welcome.
So section 2, we're now going to jump into legislative statutory changes that were effective July 1st, 2021. And this was a banner year for changes. I've never in my 28 years of practicing law seen this level of modifications to Chapter 718, again, governing condominium associations, Chapter 720, which governs homeowner associations, Chapter 719, which governs co-ops. And just to put a pin in our reserve discussion topic, I'm going to jump to the issue pertaining to homeowners association reserves. The statute involving homeowners associations was clarified to state, parroting what Nicole just said, that reserves will only be considered mandatory. Again, this is just for HOAs. If you're managing a condominium association, you could take a 2-minute nap. Don't worry about it. Reserves will only be considered mandatory if they are approved by a majority of the total voting interests. There's an or. So if you have 100 owners, 100 single-family homes in your HOA community, you need 51 homes to vote yes. We want reserves to be mandatory on a go-forward basis. That's a pretty rare event. I don't think I've seen more than maybe once or twice where membership have voted in that manner. primarily because the board probably doesn't think it's a wonderful idea because assessments will go up as a result due to the increase in the budget. So it won't even be put before the membership. The membership has the right to force the board to consider that issue, but ultimately it's up to the board to put it before the membership. The membership can't force that upon the board. It will start with the board of directors, say, yeah, we think this is a good idea. Even though we're not obligated to collect reserves, we want to make it mandatory on a go-forward basis. And that's going to be our legacy as the 2021 board of directors. And we're going to put this vote before the membership. If that occurs, and 51 out of the 100 in my hypothetical vote in favor of mandatory reserves, then it's mandatory. The other situation where HOAs will have mandatory reserves, which again is a rare event, but sometimes it does occur, is when the developer in their original set of governing documents they created, which almost always start with the word declaration, covenants and restrictions, something along those lines. If the developer put a provision in that declaration making reserves mandatory, it has to be real crystal clear that reserves are mandatory and to be collected on a year-over-year basis. If that exists, then reserves are mandatory on the HOA side. Now, I see oftentimes with homeowner associations that they will actually still budget for the collection of reserves, even though it's not mandatory in their community. They'll even have a line item in their budget that will say reserves, and money that comes in from the assessments are set aside and put into a special account labeled reserves. Well, guess what? Just as Nicole was saying, those are not reserves. We could label it that way, and that's a noble purpose for the association to do so. However, you should be aware, and the boards that you manage should be aware, that if the association needed those monies for any reason whatsoever, they, unlike in condominium association world, the HOAs can dip into that reserve account because it's really not a true reserve account. It's just labeled as such for any project, for any reason, for any budgetary shortfall, to give the property manager a gigantic Christmas bonus. They can do that. It's not mandatory in terms of those monies being used for special projects on a compilation line basis, like for condominium associations. It's really another way to say it. It's like a contingency fund. It's perhaps a better, accurate description of what those monies are set aside for, even if it carries a label of reserves. So that was one of the multitude of statutory clarifications or changes made in 2021. Here's a whole bunch of others we're going to run through. And this, now I'm back to condominium associations, then we'll jump back to HOAs. So bids for work must be, to be performed, must be maintained for at least 1 year. So if there's a project that you guys are bidding out on the condominium association side, and you get 3 or 4 bids, which is common, the bids that didn't result in hiring that particular contractor, you're still going to hang on to those for a period of a year. So don't just discard those, even if the bid was completely ridiculous and really was never considered by the board. It's still a business record and must be maintained for that 1-year purpose. As relates to business records, renters are given slightly more rights now in the world of business records. They have the right to inspect and copy the declaration, the bylaws, and the rules. Previously, I don't know why the statute was set up this way, but the renter was only allowed to inspect and copy the bylaws and the rules. But now it includes the declaration of condominium, which are available to the public records anyway, but for business record inspection requests, the renter has that right. An association may not adopt rules requiring a member demonstrate any purpose to inspect the business records. I've seen this from time to time where rules perhaps are adopted by boards as involving business records inspection requests, where the form itself asks the member to articulate a reason why they want the records. You can't ask for that anymore. They're entitled to the inspection of the business records, regardless of the reason, even if it's an untoward reason, even if it's a reason that we don't like so much. Okay, for condominiums with 150 or more units, an association, in lieu of posting copies of documents to a website, you could actually now download an app and have the membership download an app and they could access documents through that app. It's just another technical option here, which is Vinteum, I know, provides that service. So if that becomes something of interest, contact them. This clarifies a debate. Did you want to chime in there, Jen?
Yeah, I have a question for you. You mentioned voting interests. If a master board is composed of the sub-associations without specific document rights to homeowners for any votes, do the homeowners have any rights and laws to limit the master board spending or assessments?
Almost always no. The master association is its own entity with its own board of directors, typically comprised of representatives of the sub-associations, and those members of the master association board of directors will have the right to spend money as they see fit, of course, in compliance with Florida law. But members of a sub-association really have no say-so over what the master association spends its money on. That's why the sub-associations typically have a designated representative to be on the master association board of directors to help make those decisions. Okay, as it relates to being on a board of directors, again, we're still in the world of condominium associations. There was some confusion come July 1st, 2018, where there was a term limit established of no more than 8 years consecutively. So the question that arose is, as of July 1st, 2018, if someone had been on the board already for 12 years, does that mean they are termed out come July 1st, 2018? So the issue legally was the July 1st, 2018 statute to be applied retroactively, meaning we look back and see how many years the board that member served on the board, or applied prospectively, meaning we only they start counting the 8 years as of July 1st, 2018. Quite a bit of debate went on involving that issue and an interpretation of the legislative history of the statute, and to avoid litigation and continuing legal debate which is quite extensive among community association practitioners, the legislature confirmed that it is just prospective, meaning that you count the 8-year period for term limits involving condominium association board of directors as of July 1st, 2018. So no one really is termed out at this point because we're just starting that 8-year period as of 2018. We're 3 years in. Transfer fees, you guys are probably aware of this, are now increased to $150, previously from $100, that $100 cap. It is to be adjusted every 5 years based upon the consumer price index. My personal opinion, a little editorializing here, I think that number is still too low, but so be it. Petitioners in recall disputes may now choose to go directly to court as opposed to the Division of Condominium Arbitration in Tallahassee. So recall disputes are fairly rare, but if directors are, there's an effort to try and recall a director and the board doesn't accept the recall procedure, which is a whole different topic I could spend about an hour on, the owners that are seeking to have the board member recalled, they now have a choice procedurally. They could file a lawsuit in circuit court, or they could go still to the Division of Condominium Arbitration section. Next, contracts with a service provider that is owned or operated by a board member or certain relatives with a financial relationship are no longer prohibited. I'm not sure the esteemed wisdom behind this change. I thought it was always a good idea to keep separation between members of board of directors and their ability to have their business or their relatives' business be hired by that association from a conflict of interest perspective, but that's no longer a per se conflict. There's still a whole slew of requirements and hoops that need to be jumped through in order to allow that to occur. Namely, very specific meeting minutes must be adopted and include and various provisions which really derive from the Florida Not-for-Profit Corporation Statute side of things, not the Florida Condominium Act. That needs to be in the meeting minutes if there is a board member whose company is being hired by the association. You need these very special meeting minutes that need to be included or drafted rather. You also have to make sure that that board member is recused from voting, and you need 2/3, not a majority, 2/3 of the remaining board to approve that contract. Then you have this other kind of obscure odd provision where whoever has shown up at the board of directors meeting membership wise to where that particular contract is being considered, those members can actually vote down that contract, which is an odd little procedure. But if you have 7 folks show up at a board of directors meeting where the board is considering to accept a certain contract where that company is owned or operated by a board member or a board member's relative, and 4 of those 7 vote no, we don't think this is a great idea, then the contract does not go through. Next, to get into the world of alternative energy and promote that, the statute has been changed where the board cannot prohibit the installation of a natural gas fuel station, as long as, of course, these types of natural gas fuel stations are compliant with federal, state, and local laws. And the board may make available for installation vehicle charging stations. And here's the key part: without the board having to go through the material alteration voting process, and primarily involving condominium associations, if there's a material alteration to any of the common elements, which the installation of electric charging stations would be a material alteration for sure, you would need a certain percentage of the membership to approve it. Typically it's 75%, a pretty high threshold. So the legislature said, we're not going to force condominiums to get that 75% vote. If the board is in favor of promoting and installing electric charging stations in the parking spaces, then they could do it alone without having to get that membership sign off. Okay. This is a fairly big change. So if I would pay close attention to this in the condominium association world, many disputes with owners in the condominium association context, particularly involving covenant enforcement, if an owner is not doing something they're supposed to do, like paint their or remove their dilapidated looking hurricane shutters. Those disputes previously were had to be adjudicated with the Division of Condominium arbitration section. Now, the choice here is to go to the Division of Condominium or to use the statutory mediation process that is common to homeowners associations, whereby the condominium association can send a statutory mediation demand letter forcing the members to sit down in a mediation setting to try and work the matter out. If the member refuses to participate, or they go through the mediation with you and there's no resolution, there's an impasse, then the condominium association would have the option to go straight to court. They can bypass the Division of Condominium arbitration section. So that's a fairly large procedural change in terms of resolving disputes in the condominium association context. And for recall disputes, election recall disputes, mediation will not be an option, just so you know that. Those disputes will have to be either arbitrated or you can actually file directly in court, but you can't use the mediation process for recall disputes, election disputes. With all that we've gone through with this past year and a half or so with COVID, the statute was properly clarified to kind of make it in conformance with what we're all doing anyway in terms of COVID and the protective procedures that we've been utilizing. So the statute has been crystallized to make sure that the emergency powers that we've utilized for membership meetings, for board of directors meetings, for elections, for in some cases shutting down certain common amenities, that does a contagion, which is the word that you'll now see in the statute, does trigger the usage of emergency powers. Previously, the statute really was more focused on hurricanes, of course, because that's typically what we think about in terms of the usage and need for emergency powers. But COVID changed all that. So now we have clear-cut statutory guidance that contagion, the pandemic, entitles the board of directors to utilize these types of emergency powers. And that includes board of directors meetings and committee meetings and membership meetings, and it makes it crystal clear in the statute that these meetings, which we're already kind of all doing anyway, can be done by way of telephone or video conferencing or other type of video communication. Again, as long as proper notice is given, and the notices have to make reference to how folks are able to access these meetings with either the Zoom instructions or whatever, or a telephone number if it's a conference call. So, regardless of these emergency procedures, the membership still will always have the right to participate. And they must always be entitled to access to these meetings, with the rare exception that it's a closed meeting, which only comes up in the rarest of circumstances when it's with an attorney discussing pending or threatened litigation, or discussing sensitive personnel related matters like hiring or firing a particular person or company. In all other contexts, the meeting must be open to the membership, and if it's a video conference meeting, no problem, but the membership have to be given the opportunity to log in, to view, to participate as appropriate. Looks like Jennifer has something to say.
I got a question for you. If an HOA has specific reserve funds and wants to change to pooled, is a membership vote required?
Well, remember, HOAs almost never have mandatory reserve funds. So those quote unquote reserve funds that may be labeled as such are to be used for any purpose whatsoever. In the incredibly rare case where the HOA has mandatory reserve funds, it's going to follow the condominium structure in terms of the silos of categories, but you can opt to go use a pooled method, which is a wonderful alternative and makes it a little less stringent, where whether condos or HOAs, they'll have the ability to say, okay, we have all these monies set aside as mandatory reserves, but it's pooled, and we could dip into that pool for any one of the several projects that that classify as an item that where there's a replacement cost of $10,000 or more. That's the idea behind the pooled concept versus the forced setup of compilation, or as I like to say it, monetary silos. So sure, if pooled is the desired method, and it almost always should be, gives the board a little bit more flexibility, pooled can be used. There's a danger though in using the pooled method, because if you have a big project that and you use too much of the reserve accounts, or almost all the reserve accounts, you'll be left with little to none in your reserve account for these other important big ticket $10,000 plus projects. So that's the negative, I guess, of the pooled account methodology, but the positive being the flexibility to dip into a goodly portion of the reserve account to address a particular project up front. Okay, since we were talking about the emergency powers and what the associations can do, let me talk about what they can't do, and what the statute just made clear, because this was an issue that I saw quite a bit of. An association may not prohibit owners, tenants, guests, agents, or invitees of a unit owner from accessing the unit and common elements and limit common elements in general, as it relates to the real estate alienability of property. Alienability meaning the renting or the selling of the property. So what I saw quite a bit of, and I received many calls, particularly in the beginning stages of the pandemic. Scott, we want to prevent open houses in these condominium units. People are going in and out, and we want to limit the foot traffic and the possible transmission of the virus in our community. We've got to protect our residents, right? Well, that's obviously a worthy and noble idea. However, the legislature felt as if that was going too far, that you can't prevent someone from going through the exercise of trying to rent out their unit or sell their unit. And part and parcel to that is letting people see the unit, whether it's the real estate agent and or the prospective tenant, prospective buyer. That doesn't mean you can't force them to sign in or perhaps wear a mask, but a wholesale blocking of folks going in and out of the building for those reasons is not permitted. Okay, next. This is a minor thing as we're up. Got
Sorry.
Jennifer, question
I
now.
just, yep. The reserve funds are already set up. Can the HOA board switch to pooled?
They would have to take a vote for that purpose, yes, and a majority would control. Now, in the condominium world, you would need to have a vote of the membership for that purpose. A vote of the membership is required for condominium associations to switch methods from compilation to pool. And the requisite vote for condominium associations is as follows. You need to have a quorum of the membership present in person or by proxy. And then as long as you have that quorum, you need a majority of those persons to agree to vote for that pooled method. HOAs, it's different. The board alone could say, we are just going to be going to the pooled method, and that would be sufficient.
Thank you. And I have another question. She said she missed the part about the masks.
What's that? Say that again.
She said she missed the part about the masks.
The masks? Okay. Well, what I was referring to in relation to the masks, that what the association cannot prevent people coming in and out of the building to view a property, whether for rental or for a possible sale. That doesn't mean that the association could not have certain reasonable procedures. The signing in of these folks, as well as require that they wear a mask while inside. That's perfectly appropriate and reasonable. But there cannot be a prohibition of a real estate agent, of a person interested in renting or buying the unit from coming into the property, on certain days or times in a wholesale manner that really effectively limits or prohibits the owner from selling their unit. Let's talk about fines. Fines are now due 5 days after the notice of the approved fine is provided to the unit owner. Previously, the statute stated that fines were due 5 days after the date of the fining committee meeting took place. So it's now there's just a little bit more time technically for the fined owner to pay that fine. This is a topic that I'll be hitting in section 3, but it's so important. I just want to blurt this out. There's absolutely no possibility of imposing a fine in any situation, no matter how egregious the violation, if the association does not have a properly constituted fine committee. So no fine committee, there's not even a discussion. A fine cannot be imposed. Even if the board wants it in the worst way, and even if the board decides to impose the fine, without a fine committee, it's an improper imposition of a fine. And to levy a fine in that situation improperly would potentially be a violation of the Federal Fair Debt Collection Practices Act. And significant liability can flow from just shooting out, hey, you've been fined, without actually following the fine procedure and the fine statute, which starts with and ends with the proper constituting and the existence of a fine committee, which is 3 persons, at least 3 persons, and those 3 persons cannot be a board member, nor can those fine committee members be related to a board member. Okay. HOAs. There's a couple adjustments here in Chapter 720. This is an important one actually, where the definition, and it really flew under the radar, but it's something to keep in mind. The definition of governing documents was changed to take out from that definition rules and regulations. The world of governing documents, both for condos and HOAs, typically are the declaration, which really is the main kind of big book of covenants and restrictions and obligations. Your bylaws, which you see from a nomenclature standpoint, people throw out that word bylaws all the time in lieu of saying declaration. Bylaws are really just the internal procedures primarily involving the board of directors and some ancillary parliamentary procedures. So the bylaws are typically an exhibit to your declaration. Your articles of incorporation, also technically part of the governing documents. The articles of incorporation are essentially the birth certificate for the entity, for the HOA or the condo association or the co-op. And that's the first document that gets filed with the Division of Corporations. When the developer way back when decided to build this community, you'll see articles of incorporation. If the community is super old, it might be entitled charter, because that's what it was called back in the 70s, as opposed to articles of incorporation. So those three documents are traditionally known as your governing documents. I'm asked this question, oh, what if the bylaws say one thing and your declaration says something else? I mean, what controls? The order of priority as established by the statute is as follows: declaration as the highest priority, bylaws, then articles of incorporation. Now, what we used to have in the HOA statute are that rules and regulations were part of that group of governing documents. That became important because any modification, any amendment, no matter how small or how big, whether it's a wholesale rewriting of your rules or just a minor adjustment to your rules, that necessitated a recording of those amended rules in the public records for those rules to be enforceable. A procedure that is oftentimes and has been skipped. So if you have a modified rule, and this was only post 2018, by the way. So say you have one of your communities, they changed the rule in 2020 and properly adopted the board directors meeting, but never made its way over to the attorney for recording in the public records. It was unenforceable until that amended rule was physically recorded in the public records. And there's a special way to do that. Now, what the legislature did, they took away from the definition of governing documents, rules and regulations. So amendments to rules and regulations now need not be recorded in the public records. Makes life a little bit easier. Is it still my recommendation we record it anyway? Yes. Just because if it's in the public records, you have an additional argument saying, hey, owners, you're on constructive notice of everything that appears in the public records anyway. That just eliminates the possibility of any type of argument saying they didn't receive a copy of the amended rules. But at least there's not, the association won't get tripped up from a legal perspective or by failing to record these rules on a go-forward basis. Okay, what do we have next? Jennifer? Question.
Yes, just to clarify, if an HOA has statutory reserves as adopted by the members and put in the bylaws, the current board can opt to switch to pooled reserves by a vote of the board. Do they
Correct.
have to adopt a resolution?
Yes. I mean, resolution, it doesn't have to be in the form of resolution as long as it's reflected in meeting minutes. Yeah. So whether it's recorded in a drafted resolution, which some boards prefer to have these written resolutions, or if it's reflected in meeting minutes, it's all about just having a record that took place. So whether resolution, meeting minutes, either will work. Here's an important HOA change. So everyone perk up a little bit. This is an important one. The change in the HOA statute involves the transporting, I like that word, the grandfathering of rental rights that have been in the Condominium Act for many years over to HOAs involving rental restrictions. Let me break this down. So, and I'm going to start with what the Condominium Association Act says, because it helps us folks in HOA land understand what the change is. With condominium associations, if the board is seeking to restrict rentals and they want to adopt an amendment to the declaration of condominium to that effect, absolutely, they could do that, no problem. However, existing members of that condominium association who do not vote in favor of that rental restriction are not bound by that rental restriction. So you could have kind of a Swiss cheese effect where you have a rental restriction that's adopted by the condo association, where it's binding on certain owners and not others. However, future owners that take title to their property after the amendment has been adopted, restricting rentals, those future owners are absolutely bound by that rental restriction because they're taking title to the property, subject to all the governing documents, all the amendments that have been recorded in the public records. But it's important to note that that newly adopted rental restriction will not apply to the existing owners if they haven't voted for it. And there's a carve out involving, well, I guess the best way to say it is the Airbnb type rental arrangement. For instance, if the condo association seeks to restrict rentals to where the rentals have to be at least 6 months in length and no more than 3 times per year, well, that's a proper rental restriction which will bind everyone, whether that member voted for it or didn't vote for it, if of course it passes and the requisite membership vote is obtained. So that law that exists for condominium associations now is in place for homeowner associations, which was not the case before. So with HOAs, here it is. If your board of directors seeks to amend the governing documents and it's put out to the membership for a membership-wide vote, which usually requires a 2/3 vote, sometimes more, sometimes less, and you get the requisite membership vote in terms of a rental restriction, existing HOA members who do not vote for that rental restriction are not bound by it unless it's a restriction pertaining to this Airbnb situation like I just referenced, where you're trying to say no more than 3 rentals per year and all rentals have to be for at least 6 months per year. It's really kind of addressing the transient Airbnb VRBO type of arrangement that the legislature felt was a good enough reason to allow HOAs, just like condos, to have these restrictions passed without having certain members not bound by them. So it's important that your boards know this going in if they want to try and address and make it real hard for existing and future owners to rent their property going forward.
Can I just interject something?
Sure.
Going back to the reserves, where they're voting, HOA is voting for pooled. If you keep it in a just a document of the minutes only have to be stored for 7 years, right?
Right.
So if you make it a resolution, it's kind of a permanent document change, you know, past the 7 years. Just something to consider.
Well, resolutions also, you know, they're technically only need to be kept for a period of 7 years. So it's, you don't have to keep those indefinitely, but resolution perhaps, because, you know, listen, I understand what you're saying, Peggy, and for large decisions like that, it's, you know, I think it does make some sense to have a resolution adopted. It looks a bit more formal in nature as opposed to just having the reference in meeting minutes to a vote that occurred. Resolutions oftentimes are drafted by attorneys and has, you know, some nice legal nomenclature that makes it feel and sound more official. So that's a pretty big decision in terms of dealing with reserves. So yeah, I agree. It's, you know, a good suggestion to make it in a resolution. It doesn't necessarily make it non-binding if it's just in the meeting minutes. So next, there's a whole series of important points, practice tips, topics that I like to hit in this webinar. And the first one, which I'm going to turn over to Nicole, are annual audit obligations and what goes along with that whole process.
Sure. Mine's not as exciting as Scott's. All the legislative updates, I've been taking notes because it's so important. And so many every time I take Scott's class, I learn something new. So it's wonderful. The annual audit obligations actually hasn't changed in a few years. So, but you need to make sure as a property manager that you know what the requirements are, because especially you're at budget time right now, and making sure that you are following the report correctly, because you need to make sure that you do that before year end. So this applies to 718 and 720. Condominiums and HOAs fall under the same for their annual obligations. The first thing is every association is required to file a tax return. I've had many associations say, well, we're a nonprofit, we're not required to file taxes. You're actually a profit organization with the IRS. So you are required, every association, to file a tax return. Doesn't mean that you'll pay taxes, but that is required. On the statutory side, there is income levels where you're required to do certain reporting. Now, if your documents state something different, you would need to talk to your attorneys. Some documents are old and some of them have where you're required to do an audit. It doesn't have anything based on the income. So you would need to speak to your attorneys if there's something in your documents regarding that. But for the statutes, if your income is $500,000 or more, and that includes all revenues, special assessments, reserves, anything that is revenue, that is what is included. So over $500,000, you're required to have an audited financial statement. If your income is $300,000 to $500,000, you're required to have a reviewed financial statement. And then $150,000 to $300,000 is a compiled financial statement. A compiled financial statement does not have to be done by a CPA firm. It does not state in the statutes a CPA firm has to do that. But you must be aware that it does have to include all of the footnote disclosures. It must include a full report, a compiled report. So some management companies might put that together, but if it doesn't include all the footnotes, it's not a true compiled financial statement. So make sure it includes that. And anything under 150,000 only requires a cash disbursements, cash receipts report. I always tell my associations that are 150,000 or less, I would always at least have a compiled financial statement. The cash disbursement and cash receipts report is really, there's no financial benefit to anybody. There's no accounts receivable reported on it. There's no accounts payable. If you have a loan on the books, it's not recorded. So it doesn't have a lot of information to the owner or somebody buying into your community. And the board of directors has a right to step up in service. It is not a membership vote. So if you're required to do the cash disbursement, cash receipts report, as a board, you can vote to do the compilation, or you can vote to do a review, or you can vote to do an audit. It's only a board decision. However, if you decide you do not want to do an audit and you're required, you do have the ability to step down in service, but that requires a membership vote. And it must be done before year end. So you would have to do it before December 31st. And they changed the statute a few years ago in the sense that it used to say that if you waived your required reporting and did a lower level of service, every third year you had to do the service you required. That is no longer in the statutes. So if you waive the audit, you could waive it every year and you could do a lower level of service every year. It's not required anymore. I always tell my associations, it is a good idea that if you're doing a lower level of service and you voted on it to do a review or a compilation, it is good every couple of years to do an audit, just to give recommendations or some updates on things you should be doing better, recommendations on better internal controls, how to run the association, things like that you don't get in a review or compiled financial statement. But if you do step down in service, it does require the vote of the membership. You would need to reach out to your attorneys to get the wording on how to do that voting. It's similar to like waiving reserves, a similar vote, but you would ask your attorneys how to get that wording so you can have it done before year end.
Great, thanks, Nicole. So this part might seem, Jennifer, you have a question.
Yeah, I thought the 7-year rule no longer applies to minutes.
No, it definitely does apply.
I was told Airbnb were considered transient accommodations and not subject to restrictions on minimum rental anytime. Any truth?
Well, that's what I was referring to in terms of the carve-out exception, where adopting an amendment restricting rentals, in order for that amendment to be bound on a certain member, that member would have to have voted as it relates to that particular rental restriction. But the carve-out, as I referenced, effectively deals with the transient Airbnb VRBO situation, where if the amendment is seeking to say that you can't have more than 3 rentals per year, then as a result of these types of Airbnb situations, and that amendment passes, then even if that particular member didn't vote for it, they'll still be bound by it. All right, let me run into a couple other things. So this may be a little bit on the simpler side, but it's a good refresher in terms of the niceties, the parliamentary procedure in terms of how to run a board meeting. We all know the president really has one role as the president. It's not to do everything, and it's not to decide everything, even though you have some communities where that's the case. The president's function is effectively boiled down to one task, which is to conduct the board of directors meeting. The president doesn't have any more authority beyond that. They don't have 4 votes versus 1 vote for the other members of the board, and they can't make decisions all by themselves. But the president does have the important job of making sure that the board of directors meeting follows a certain agenda and they tick through the various items. In order to have a board of directors meeting, you have to have a quorum of the board. So you have 5 members on the board of directors, you have 3 present, obviously you got a board of directors meeting. And this is where folks get tripped up a little bit, and there's kind of a rampant violation of Florida's procedure in terms of board of directors meetings. When you have, in my hypothetical, 3 of those 5 getting together at someone's house to discuss association business, guess what? You have a quorum of the board, and that should have been a noticed board of directors meeting. Does it happen all the time? Of course it does. I know it does. But it's incumbent upon you as a property manager just to remind your board that shy away from having a quorum, informally get together to discuss association business. That doesn't mean they can't socialize together or play pickleball together if they want. But the second they all sit down and start considering to hire this particular contractor, or what should we do with this violation, that's association business. And you have effectively a board of directors meeting that has not been noticed, and that's a violation of both Chapter 718 and Chapter 720. I've heard this phrase a lot, executive sessions or workshops and that type of thing. I'm going to go back to what I said before. There are only 2 exceptions to a board having the right to close a meeting. But then I've been asked, but Scott, we just have to toss around these ideas to figure out how we're going to attack this special project. And if the members are present, it's going to take 4 hours instead of 1 hour. Well, sorry, but you can't close a meeting to have an internal board of directors workshop. That doesn't exist. You can have a workshop in the context of a properly noticed board of directors meeting. You can have a board of directors meeting, notice to the community, where on the agenda is the discussion as involving consideration of various contractors for a particular project, for example. So you can't allow your boards to do that, except in those 2 scenarios, the 2 exceptions that I had referenced before. One, where your attorney is present at the meeting and there are discussions involving pending or threatened litigation. So if there's a lawsuit that's going on involving the association and the attorney is involved in these discussions, whether on the phone or actually in person, then that's attorney-client privilege type discussions, and is proper, and it's in fact necessary to close the meeting where members should not be present. The other one is if the board is considering certain personnel matters, hiring or firing someone, then you could close a meeting for that reason as well. It's still, you should be noticing the meeting, but noticing it as a closed meeting that the members are not allowed to be present. I see this all the time in the board of directors meetings that I attend, where the members feel as if it is their opportunity to sling questions at you guys, or not, both at you as well as the board of directors. And if the question is well-intentioned and nicely stated and not rude or impertinent, there's no harm, obviously, in answering questions from the membership. But just be aware of this. In scenarios where it becomes overbearing, or the tone is improper, or it's accusatory in nature, or it's causing the extension of a meeting, hours upon hours, just know you have this arrow in your quiver, which is the membership do not have the right to interrogate, question you as a property manager or the board at the board of directors meeting. While they may think they do, they don't. What they have the right to do is speak on an agenda item that is being voted upon by the board, or any agenda item for that matter, for upwards of 3 minutes, and I would time them. But speaking does not mean fling questions at you, or whether it's in a nice way or in a not nice way. So in a situation where board of directors meeting is getting a little out of control because you have some hostile members saying things that are out of line or demanding answers, they have no right to make those demands. And you can shut it down and give folks the 3 minutes. And when they're done with their 3 minutes, thank you, and move on to the next person. And I'm going to move on to Jennifer. She looks like she has a question.
Two questions here. I have the first one. Didn't the status change in July of 2018 that minutes must be kept forever?
No.
And is it proper for board members to communicate via email, which involves doing business via email?
Great question. I was about to hit that, and that's exactly consistent with what the topic I was just discussing. So emails, and I'm asked this quite a bit, and I see this quite a bit. Generally speaking, boards must shy away from email discussions. The reason is emails are what? They are the deliberations of the board. The deliberations of the board are supposed to be open to the membership. Just like for governmental agencies and the sunshine laws, that you may have heard that term. The idea being when a government, a body are making a decision on some level, it's supposed to sunshine on that decision-making process must be laid so the electorate can see how a certain body is coming to make a certain decision. Same concept with associations, where the deliberative process is supposed to occur at a board of directors meeting in the open, not behind closed doors per se, by way of email deliberations. Does it happen? Of course, I see it all the time. And the example that I give were the limited circumstance where email deliberations are acceptable. I break it up into kind of big decisions and minor decisions. And that's really kind of two great topics. But in terms of the example, something minor, this is my hypothetical I like to use. If the property manager is going to, you as a property manager, are going to send an email to the entire board saying, hey, we're going to change the maintenance of the pool from Tuesdays to Thursdays. Anybody have a problem with that? That type of email exchange back and forth, it's not a problem. That's very minor, ministerial in nature, as opposed to, hey, should we decide to pave the parking lot, and is it the right time to do so? And should we impose a special assessment, or should we get a loan? That's a pretty big issue, right? That needs to be bantied about and deliberated during a board of directors meeting. It's not supposed to be done by way of email. So keep that in mind. Videotaping and audio taping. If a member wants to come and videotape and audio tape a board of directors meeting, they have the right to do so. It may be uncomfortable, but they have the right to do so. The statute states basically that the association, whether it's condo or HOA, they have the right to set rules and regulations involving audio taping or videotaping. For example, you can't have lights coming from some video camera that are going to be disruptive to the boards and in terms of light shining in their face, or it can't be emanating any type of noise that's going to be disruptive to the meeting itself. And notice of the videotape and audio taping is generally to be given at least 24 hours in advance. But there cannot be a wholesale prohibition on videotaping and audio taping. The different notice time periods for board of directors meetings, it's virtually always 48 hours for your typical board of directors meeting, but you have budget meetings. Notice of budget meetings carries a 14-day notice. Annual meetings, for condo associations, you have the 60, 40, 35, 14, which is 60 days before the annual meeting. The first notice goes out. 40 days before the annual meeting, there is to be the individuals who seek to run for the board have to turn in notice of intent to be candidate forms. 35 days out, those same candidates have to turn over resumes if they choose to have those resumes sent out. And 14 days before the board of directors meeting, that second notice of annual meeting goes out where the names of the candidates along with their resumes are to be submitted to the membership. For HOAs, although many follow the 60, 40, 35, 14, it's not mandatory, and it comes down to what your governing documents say. And more times than not, HOA documents, bylaws, do not reference the 60, 40, 35, 14-day procedure. Usually it's just a 14-day notice. But is it good practice to do the more extended notice of 60, 40, 35? Yes, on the HOA side. But it's suggested that either there be a modification, i.e. an amendment to your bylaws as an HOA to make that mandatory, or at a minimum, at least have the board adopt a resolution to that effect. Okay, vacancies on the board, then I'm going to shoot it back over to Nicole in terms of preparation of budgets and consideration of issues relating to the preparation of budgets. Before I turn it over, vacancies on the board. Let's say someone resigns, moves away from the community. What is the obligation of the remaining members of the board to fill that spot or not fill that spot? It is a function of how the bylaws read. If the bylaws say that upon a vacancy, whether by resignation or death, etc., if the bylaws provide that upon that vacancy, the board shall, that's the key word, seek to fill that vacancy, then that's what you got to do. You got to make an effort, to fill that vacancy and solicit folks for that purpose of filling that vacant seat. If the bylaws say the remaining members of the board of directors may fill that vacancy, then there's no obligation. It's up to the board to fill the vacancy or not fill the vacancy based upon majority of the board's decision-making process. And what term does that particular board member, the new board member who has been appointed, have? Again, it's a function of the bylaws. It may say that newly appointed board member who is filling that vacancy will fill out the remaining term of the resigning member. That's more common. Sometimes, though, it says that newly appointed board member will just fill the spot until the next election. So it comes down to the precise language in the bylaws and not what the board wants or thinks should occur. Really do have to take a look at the bylaws when there is a vacancy as a result of a resignation or a death of a board member. So preparation of budgets. Nicole, it's all yours.
Great. I'll try to do this as quick as possible. I know sometimes it can go long with budgeting. So the first thing is, hopefully most of you are working on your budgets right now and almost done them. I always tell my boards, try to reach out and do your budgets in probably around July, August. It's great to get started early because you want to reach out to all your vendors and you want to reach out and find out about the increases, to find out about if things are going to change, especially in this year. Many of my boards started very early this year. As all of you are seeing, I'm sure out there, and everybody is, cost of inflation is really affecting the budgets this year. Reserves, the calculation of the reserves, a lot of them are getting updated reserve studies for their budgets because they're noticing that the cost of those estimated replacement costs have significantly changed. They're reaching out to their vendors because labor has changed, parts, materials, everything, that everybody is having a trickle effect. Every association that I've worked with this year probably has increased a minimum of 2% in their budgets. I haven't seen anybody that's kept it the same. Most of them are raising it because most of the contracts have gone up. So it is something to consider if you're doing that. Some of my board members or some of my managers will actually send a letter to every contractor and ask, what are the increases going to be? So they have an idea of where they're at in order to get the proposal in so they can get an estimate of what that budget is. One of the most important things when you're preparing a budget is to know that it's just an estimate. It is not a dollar for dollar. There are going to be line items that you are over or under. You want to get as best as possible, but it's never going to happen exact. I have some board members that try to get it down to the penny. It's not how it's going to happen. You're going to have overages and unders at year end, but it is something to look at. Also looking at the reserves. I think that's the most important part of your budget. Besides, I know operating, but your reserves are very crucial, is making sure that, have you had the reserve study? If you haven't had a study, is those numbers up to date to make sure that that fully funding number is correct? And then if you're not funding reserves and you've made a decision, the community's made a decision to partially fund them or waive them, what do you have on the operating side to cover things that happen? For example, your hurricane deductible? Do you have set aside a non-statutory hurricane deductible if something does occur? If you don't have reserves, do you have enough in your contingency line item in the operating that if something happens, how do you cover that? A lot of associations, what they've done in the past is if they're not funding those reserves and they don't have enough in contingency, which they should, is they're setting aside a line of credit. They're putting a line of credit together. They're reaching out to the bank and having that for emergency situations. Also, a lot of my communities, what they're doing in the last year is a lot of them have said interest is great. It was at that point that let's start to do those projects, put them into our budget, possibly go out and get a loan and take that interest rate, which is great, and start doing those projects now. It was interesting, but through COVID, a lot of my communities did a lot of work on their buildings at that time because money was so reasonable. They reached out to the banks. They said it's a perfect time to get a loan. They built it into their budget to pay back the principal and interest rather than special assessing. They put it through their budget. Either way is allowed to be done. The only downside to putting it through your budget, if you do that, is that your maintenance fees increase. And when that loan is paid off, are the maintenance fees going to go back down based on that? No, you're going to end up using that money for something else. So a lot of people will say, well, let's put it through a special assessment. And then also making sure that, a couple important things on a budget, making sure the budget balances. You'd be very surprised that when I go into audit time, that the budget does not balance, that there's a surplus. In a budget, you don't have a surplus. If you're looking to end the year in a surplus, then what you would do is you would add in more into an expense, but the budget must balance. And then that would help you to end the year with a surplus. Any surplus that is ended at the end of the year, the board has the right to move that into a reserve or use it for future projects. And then also make sure that when you're putting a budget out, it's very important, I feel also as an auditor to the community, is making sure you're being transparent as possible. I would always include the last year's budget. I would always include actuals, even if it's through 6 months, and then do an estimate through the end of the year. So people can kind of look at that budget that you're proposing for the next year and know an idea of where do we spend in the current year? Where do we budget in the current year? And then also make sure the name of the association is on the budget and make sure that the time frame is. You must have the date. So if it's January through December, you must show that and the year 2021 or 2022. The state had told us that many complaints come in that the budget is not done correctly, that they don't have the dates on there. They don't have the association name. There is a structure that you do have to follow to make sure the budget is sent out correctly. That's pretty good.
Thanks, Nicole.
You're welcome.
The business record inspection procedure, this is probably the bane of some of your existence when members shooting you emails demanding copies of this and copies of that. It's important what is their statutory obligation when they make these types of requests. First off, they're not entitled to demand copies of documents. The statute, as it's set up, both for condos and HOAs, is an inspection of business records, meaning the association only has an obligation to come up with the records, assuming it is a properly requested business record, and make that document available for review within 10 business days, which should be set aside in a room, in a place, in a location within 45 miles of the community for the member to come in and say, okay, I'm taking a look at it. They could take a photo of it with their camera, with their phone if they'd like. They could flag certain documents that they want copied, of which they'll get a certain number of free copies, which are 20 in number. And then beyond that, they get charged a certain, I think it's 25 cents a page. But just be aware, the key point, the takeaway from this should be that they're not entitled to demand copies. Plus, the manner in which they make this demand is important. Shooting an email to you is actually not compliant with the statute. It has to be done in writing, and writing does not involve an email. They have to send a letter, deliver to the property manager, and that starts the clock. And the clock is 10 business days from receipt of that letter, whereby the documents have to be made available for inspection. What happens if they actually follow that? They actually demand an inspection, they send it in writing, they identify a proper business record, and it has to be specific, and it can't be too general in nature, meaning I want to see all the financial records of the association. That does not comply with the statute. They have to be more specific in terms of which financial records that they're seeking, and articulate that in the writing itself. But if there is a compliant demand for inspection made, a 10 business day clock begins to run. The association ignores it or doesn't get around to it. There is a $50 per day penalty, up to $500 cap, if it's proven that the association intentionally failed to comply with the statute, ignored it on purpose to some degree, or just didn't address it on purpose. So that could be a bigger deal in terms of not just, listen, $500 is $500, and it's never fun to have to explain to the board of directors why you're recommending that we pay a $500 fine to this member. But it could actually go beyond that. It could turn into litigation, and that $500 statutory fine, if it is not paid, if it is truly due, which it's rare when it's truly due, but if it is truly due and the association refuses to pay it, and the member wants to take it the next step, and they can file a lawsuit over it, now you're facing not just $500, but potentially attorney's fees in favor of the member thereafter to have to litigate that case. So the liability could really go exponentially beyond $500. Jen.
If management sends an email requesting an HOA board approval, a cost of a project that is not life-threatening, that issue should not be discussed or approved via email?
Generally, the answer is no. I mean, when you're talking about a project, whether it's a life-threatening type of project, a major project, or still any expenditure of any real significant, substantial amount of funds, the concept behind the open meeting is to have those discussions at the open meeting. That doesn't mean that that this doesn't occur, and I know from a logistical standpoint, in the way we all communicate with each other electronically by email, it is the most efficient way to get things done. So I'm saying this with the clear understanding that full 100% compliance maybe is not practical, but I just want you to know what the law requires, and you'll decide from there how much compliance you want to adhere to. Let me run through a few more. I know there are a lot of questions, but
There's two more, but go ahead.
Yeah, let me just hit a couple bigger issues here that I feel are important. The adoption of rules and regulations. We love rules and regulations. Why do we love rules and regulations? Because it only requires a board of directors vote. You don't have to get membership approval to adopt rules and regulations. You need a majority vote. You need to have a special meeting, which is one of those exceptions to the 48-hour notice, where it has to be a 14-day notice. And the notice has to articulate, this is for the purpose of adopting amended rules and regulations. And a copy of those proposed amended rules and regulations are to be attached to the notice. And at that board meeting, it is exclusively in the province of the board of directors to decide to adopt those amended rules or not. You should absolutely and need to give the membership the right to have their say-so as it relates to the proposed amended rule, which goes back to the Robert's Rules of Order. Make sure we have that someone makes a motion. Do we have a second on the motion? Yes, this is all being reflected in meeting minutes. Then before the board votes, that's where technically deliberations of the board can occur, but also, and importantly here, that's when you give the membership their 3 minutes, not after the vote. I've seen that occur a lot, where board of directors votes as to adopting rules and regulations. Then thereafter, the members have the right to make their comments. Well, the members are supposed to, in theory, have the ability to affect the decision-making process of the board. So that's why the comments from the membership as to the motion that is before the body, the board of directors, the 3 minutes for the membership is to occur before the vote. Once that is concluded, then you take that vote, and all that should be reflected in the meeting minutes. And rules and regulations, again, are wonderful for that purpose because you don't need membership approval. However, that doesn't mean you can't jam everything, including the kitchen sink, into rules and regulations because it's easier to adopt. Rules and regulations cannot contradict implicitly or expressly language that already appears in the declaration. So if you have something in your declaration that says the members are allowed 2 pets per person, and then the board wants to adopt rules eliminating all pets. That's not permissible. It's not going to be a valid or enforceable rule. The only way to address that situation is to amend the declaration, and that requires a formal membership vote. Typically, depending upon the language in your governing documents, typically 2/3. Sometimes I've seen 75%. The rules and regulations are supposed to have a reasonable and serve a legitimate purpose. That's the standard. It's as long as it meets that standard, it's going to be deemed valid, provided again, it doesn't contradict anything that already exists in the declaration. Big issues like rental restrictions or occupancy requirements, generally speaking, those almost always have to be in an amendment. So as much as the board would like to, and I sympathize with the board wanting to include that in rules and regulations because it's easier to adopt, in order to make it enforceable, it's that type of large substantive change and issue would need to appear in amendment requiring membership approval. And like we said, we just had this change recently where the amended rules now need not be recorded in the public records, but I still recommend they be recorded in the public records. So it still makes sure your attorney is involved in the adoption of that process. As it relates to the adoption of amendments, like we were talking about, we need a formal meeting of the membership. This is another one of those exceptions to the 48-hour rule. The notice of that membership meeting must be done at least 14 days in advance with a copy of the proposed amendment sent along with the notice. Now, the best way to usually acquire the necessary votes for a proposed amendment are through limited proxies. You include the limited proxy, giving the member the option to vote in favor or against the particular items in the amendment. And I usually prepare it in a manner where it's option 1 and option 2. Option 1 is I vote yes on all of them. You say we have 10 things we want to revise in our declaration. Give the member the opportunity to do a wholesale yes, and then that's it, and they sign it, and that's a yes on all 1 through 10. I also include an option 2 where it gives the member kind of a line item ability to vote yes on some things and no on others. If they feel strongly about voting no on a couple items, it gives the member that flexibility to do so. Those limited proxies are the best way to try and get over that finish line of getting the requisite number of votes, because the limited proxies are good for 90 days. They're good for 90 days, meaning, let's say you have scheduled that membership meeting and you have a hypothetical of 100 unit owners and you need 67 to vote yes. And we're creeping closer to that membership meeting, but we only have 48 in hand voting yes. Well, right up to that point of that membership meeting, what we do in those scenarios is we reschedule the meeting and we go out and we try and collect a few more limited proxies to get over that 67 threshold. The existing ones, the existing limited proxies that we've collected already, as long as we're within this 90-day period, they're banked, they're still good, they're still valid. So we go out, we collect the additional limited proxies, and once we get over that threshold, hopefully it's at the prior to the next scheduled membership meeting, then that amendment will pass. Let's say again, we're just short by a few. Then right before that second scheduled membership meeting, we rescheduled again, and we still have in the bank those existing limited proxies that are good for 90 days. Sometimes, and I've done this, we're taking the scheduling of a membership meeting 4 times, to get the requisite number of limited proxies. You don't have to have an original limited proxy, by the way. A fax is fine. An email scan version of it, fine. It's no problem. You don't have to have an original limited proxy for it to be a valid enforceable one. Okay, MARTA, real quick. This is where, I don't know, the hair on your neck may stand up a little bit if you represent an older community. MARTA is probably the 4 scariest letters if you're representing a community that is more than 30 years old. MARTA is something called the Marketable Record Title Act. It's a very obscure law which says the following: documents that are recorded in the public records that are more than 30 years old, if not preserved, which is the key legal word, will be deemed to be invalid, as expiring essentially. That includes homeowners associations, declarations, covenants, restrictions, bylaws, etc. This does not include condominium associations. So if you're managing a condominium association, you don't have to worry about this MARTA rule and law. But for HOAs that are older in nature, where the declaration as originally put together by the developer way back when, if it's if it's older and it's in the, say, the mid 70s or so, we got to take a look at this because we got to make sure that those documents were preserved. How do they get preserved so we don't expire at that 30-year mark? It's really pretty easy. All that needs to be done is the board has to take a vote, and a notice of preservation document, typically about a page and a half, gets recorded in the public records before that 30-day period. Then we're good for a whole nother 30 years. We don't have to think about it. So what happens though if our document, Scott, we took a look at it, it's more than 30 years old and we're not finding anything that indicates that a notice of preservation was filed before that 30-year mark? What does that mean? That means if your documents are effectively invalid, you can't collect assessments, you can't do any covenant enforcement, you can't do much of anything. What we do as a result, we go through something called the revitalization process, which I've done many times, where it's a much more involved procedure, where you have to go to the membership, you have to basically disclose to them that we have an expired set of governing documents here, in order to spring life back into our governing documents and be able to do things as an association and have the right to keep our community safe and clean and collect assessments and etc. and budget and all that goes along with a homeowner association. We need 51% of the members to vote in favor of revitalizing the documents. But it's a much more involved process than I'm describing. All the governing documents have to be sent out along with revitalization ballots. An organizing committee has to be set up. It's a quite involved, expensive procedure, which costs typically thousands of dollars, as opposed to the notice of preservation. If we remember to do that before that 30-year mark, it costs nothing except perhaps less than $20 to record a notice of preservation instrument with the public records. But if you fall into that post 30-year period, we can and should and really must go through that revitalization process in order to get your community back on proper footing to do things an association is entitled to do, because the rights and obligations of an association and its membership derive from the governing documents, derive from the validity and the language and the provisions of your declaration. If they are inoperable pursuant to Florida law because it expired under the Marketable Record Title Act, it's disastrous potentially for your association. There's also a very obscure statutory procedure that came to being a couple years ago, where each and every year, even if your community, your HOA has properly preserved and it's not a worry, technically each year, and you should know this as a property manager, the first meeting after your annual meeting, each and every year, the board is supposed to take a vote to consider to preserve the documents. Now, it comes a little silly, honestly, if you just preserved a few years ago. We've got another 28 years before the documents expire again. It's not really necessary to preserve it every year. But just know that statutorily, the association has an obligation to consider year after year after year the preservation of the documents. I guess the legislature wants to really shine a light on this issue to force the boards to be aware of this concept and to address it on a year-over-year basis, even if you've got a few decades until you're facing potential expiration again. Okay, got through MARTA. I'll talk quickly about collection procedures, then I'm going to get to Nicole as to the application of monies on a delinquent account. So collection procedures. Now, I left this out of my discussion of the statutory changes purposefully because it is such a major issue that you guys probably are dealing with as property managers. The notice of late assessment document that now needs to go out before really the true collection procedures begin. So you guys are probably familiar with this, where that's involving every delinquent account, both with HOAs and condos. Before the account can be turned over to the attorney for collections, the property management company is charged essentially with the task of preparing these notice of late assessment documents, sending out to the owner, detailing the amounts that are due in the account, the delinquent assessments, late fees, interest, not attorney's fees. You cannot include attorney's fees because it has not gotten to the attorney yet, and give that owner that chance within a 30-day period to pay the balance. If they do not pay the balance as a result of having sent out that 30-day notice of late assessment letter, then the account can be turned over to the attorney for collection. I guess the infinite wisdom behind this process, which I'm not so fond of, and neither probably are most of you, is that the attorney's fees on the initial collection letter are so overbearing in theory to the unit owners that we're going to give them that unit owner who hasn't paid another final window to pay the delinquent balance within this 30-day period prior to it making its way over to the big bad attorneys who are going to send that collection notice and charge attorney's fee for doing so. So it's important in the context of if that notice of late assessment is not properly sent out in compliance with the statutory form or substantial compliance, then, and if the account is turned over to the attorney for collection, we're locked up. We can't do what we need to do because that pre-letter, that notice of late assessment letter, needs to go out first and foremost before it can be properly turned over for collections to the law firm. So be mindful of that. After the notice of late assessment goes out and it comes to us and the account has been brought current, then we can send out our notice of intent to lien letter. The time periods have been changed where it used to be 30 versus 45 in condo association world. Now it's all made 45, meaning that we send our notice of intent to lien letter, giving both for condos and HOAs, giving the owner 45 days to pay up. Otherwise, a lien can be filed against the property. Same is true as far as the step after that. We file the claim of lien if they still haven't paid, send a copy of that, and if they still haven't paid in response to receiving the recorded copy of the claim of lien on their property, then the association can decide to foreclose on the property. Just like a bank can foreclose on a mortgage, as you well know, we as an association can foreclose on our claim of lien. Whether or not it's wise to do so is a complex decision, which the attorney always has to chime in on. It's a function of, is there a mortgage on the property? Is there a mortgage foreclosure that's happening on the property? What's the condition of the property? Is the association going to be able to sell the property? Will they be able to rent it out? And what's the rentability of the property? How much is the association going to have to spend to bring the property up to a condition, make it attractive for a renter? Several factors. How much is due on the particular account? What's the cost of the litigation to foreclose on this particular house, etc. So I'm generally of the mindset of the belief that the most aggressive collection procedures are the most effective. But that final step of foreclosing is a big one, and a great deal of thought has to be put into it. I'm going to shoot it over to Nicole because I know we're fast running out of time in terms of the application/accounting procedures of monies received from a delinquent owner.
Okay, so yeah, we only have a few minutes. Just real quickly, first to make sure that you're putting in a bad debt allowance into your budget, to make sure that you're looking at the year that whoever's not paid 90 days and older, that you're putting in an allowance, so then you're not shortchanging your budget. And then making sure you're turning it over to the attorney quick enough that they can start collections if they're in the rears. Really looking at that delinquency report and saying, anybody, like I stated, 90 days and older, you should look at that and say, okay, should we be putting an allowance? We never directly write anything off. You never take it off the receivable report until you actually talk to your attorney. When we do the audit, we've had board members say, well, we want to directly write that off. And we say, did your attorney tell you you're not going to collect that? So we do rely on the attorneys to advise that. And then then the board makes a decision to write it off. If you collect that money, all that happens is now your accounts receivable gets minimized by that amount you've collected. The allowance for bad debt goes away and it gets recognized as revenue. So if you collected more, which most associations don't, then it would just be other revenue. But Scott brought up a lot of good points in the situation. If you do have a delinquency, reaching out to your attorney, should we be running this? Is it cost effective? Do we know if the bank is going to foreclose quicker, or if we're going to put money into this and then they're going to foreclose on it and take over, and then we spent all this money on it? So you really have to look at that from a standpoint of the cost versus the benefit of that unit. But we do rely on the attorneys before anything is written off. You must make sure the attorney says it is 100% not collectible. You do want to keep it on there.
Let me give you an example where we would have to write it off. In a situation where there's a mortgage foreclosure, bank is foreclosing on the property. And most of you probably know, if the bank takes title to the property at the conclusion of the mortgage foreclosure process, which is 97.6% of the time probably, then what the bank owes the association are not what all the assessments that exist on the delinquent account, but instead something called the safe harbor payment, which is a formula, 1% of the principal balance of the original mortgage that's being foreclosed on, or 1 year's worth of assessments, whichever is less. So if there's a $300,000 mortgage that is being foreclosed upon, 1% being $3,000, if the assessments on an annual basis are $2,500, so the bank would then owe in that context $2,500. Say you have $12,000 in unpaid assessments that have accrued in this account, that the balance would have to be written off. So we'd get a $2,500 payment and the rest would have to be written off. Now that doesn't mean the association doesn't still have the right to sue the owner personally for those delinquent assessments. In a very rare case would that be appropriate. It's usually not a good usage of the association's funds, but technically that still exists. As part of the mortgage foreclosure process, as well as the tax deed sale when there's delinquent taxes, more and more these days, we're seeing surplus funds. We're seeing a situation where the bank has foreclosed and someone bid on the property more than what the bank is owed, leaving surplus funds that make its way to the clerk of court. In that case, we as an association can make an application to the clerk of court, since we're in a priority lien position typically, to have a disbursement out of that surplus, which is a good way to make up some or all, in certain cases, the delinquencies that exist on that account. So monitoring that mortgage foreclosure, as well as if there's a tax deed sale, to see if there are surplus funds that come to exist post sale, and if so, make a timely claim for those surplus funds, is a great way for the association to recoup unexpected monies as a result of those two procedures. And over the past several years, we've recovered tens of thousands of dollars for our communities. So I know there are more questions, but we're out of time. I'll just remind you, you could shoot an email my way if you have follow-up questions at Scott, SCOTT, at sjwlawgroup.com. And I think you may have the other folks' contact information. And as far as I'm concerned, I really appreciate the opportunity to share some of this information with all of you. And I thank our sponsors again. I thank Peggy and of course Nicole for doing the webinar with me, and Jennifer as well.
Great job, Scott. Great information. Thank you so much.
Yes, great information. And thank you all again, sponsors. I did want to include Brian Van Dam, who's on from Yellowstone Landscape. I apologize, I didn't get him the link on time. So Brian, you want to say a few words about Yellowstone?
Well, thank you very much, Peg. Great presentation. I don't want to take up or extend any more time. Just introduce myself as Brian Van Dam with Yellowstone Landscape. If there's anything I can do, even if it's just for a consult, I know it's budget time. If you're looking for an RFP for your community, or if you have some challenges and you want an expert opinion, I'm happy to help anyway. Please reach out and contact me directly on my cell or email. I'm happy to help.
Thank you. And thank you, Jennifer and Vinteum, everybody there. And thank you so much. I look for us in the next weeks to come for more classes.
Thanks, Peggy.
Thank
you.
I still have 5 questions. Do you want me to just email them over to you?
Sure.
Okay, perfect. Thank you. Thank you, everybody.
Thank you. Thanks, everybody. Bye-bye.
Bye-bye. Have a nice week.
You
Bye-bye.
too.